Well, welcome everyone. Let me at least do the introductions while they get the PowerPoint up and running. My name is Arnie Lacayo. I am a partner with Estegaraga Davis here in Miami, and I have the pleasure of moderating this panel today. The organizers called it the 10 Commandments for Cross-Border Insolvency, and you'll see once our PowerPoint gets thrown up on there that we called it the 10 or so commandments because we have more than 10, and really there are, as many of you know, just lots and lots of things to think about in these cases involving cross-border insolvency. And so with that, I will tell you that we have a phenomenal panel today, and I'm very happy to introduce them. I will keep the introduction short because we've started a little late and we want to get you out of here on time. To my right, we have Simon Dixon from Cayman, and he is a lawyer with Morant Ozan, and he specializes in bankruptcy and insolvency matters, litigation, and financial services work as well. Okay, that is our PowerPoint, but it's upside down.
No, that's for the Southern Hemisphere. It's for the...
I'm sure we'll get it sorted out in just a second. But it will be fun that way if we do it like that. I'm sorry, I was introducing Simon. And Simon is going to cover some of the issues that we see pre-appointment. And so you'll see that the way that we organize these 10 commandments generally is to kind of think about the timeline that you see in your typical cross-border insolvency matter. To his right, we have Julie Hemo, who's with Norton Rose Fulbright out of Montreal in Canada. Julie practices commercial litigation with an emphasis on corporate restructuring, bankruptcy, and insolvency. And has lots of experience in this area. So we're very fortunate to have her here. She's going to talk about some of the commandments, if you will, for the main portion of the insolvency, and basically walk us through her perspective of this topic as a Canadian lawyer who's often instructed in these matters. And to her right, we have David Walker with PricewaterhouseCoopers in Cayman as well. He's a partner there. He focuses his practices on reorganization work, forensic investigations, solvent wind downs, government advisory, and formal insolvency appointments. And David is going to take on the commandments that we collectively came up with in the immediate post-appointment period. So you'll see us kind of working through that timeline in the insolvency matter. So it looks like they're still going up there. Maybe since we're short on time, okay. So as soon as we're ready, we'll have the PowerPoint come up there, but we've got it on here, and with that, I will turn it over to Simon, who will talk to you about the pre-appointment commandments.
Great. Thanks very much indeed. I think we'll probably crack on with the slides. I want to talk very briefly about pre-appointment commandments or issues, on the basis that pre-appointment issues aren't necessarily legal issues, but I think the pre-appointment setup and the manner in which the pre-appointment process goes can very often set the tone for the liquidation, and it can, if it operates well, meaning that one gets to the starting line, at least without there being a significant amount of infighting and difficulties. So, as you can see, I think we have 5 pre-appointment commandments, and I'm afraid I'm going to add a 6th to that as we go through it. So the first commandment is, thou shalt admit to yourself that you don't know it all and seek advice. And of course, it would be career limiting for me to suggest that there's any Cayman liquidator who knows it all. They're certainly very good at seeking advice, but it's not necessarily straightforward, I think, for a Cayman liquidator to seek certainly legal advice in the pre-appointment process. I think it's important to remember that an office holder is approached and nominated by a petitioner, but he doesn't have a cash, and he has to spend a great deal of his or her time dealing with the pre-appointment issues, so dealing with conflicts, dealing with what the job is about, what resources are required. So before they even get started, they spend quite a lot of time and resources, and so then to be asked to go and seek legal advice at expense is quite difficult, particularly in circumstances where that individual may not be appointed, may not be reimbursed for seeking that advice. And obviously there are a number of ways of obtaining advice where there's no cash. Obviously they can, if not take advice, certainly consult with the petitioner and the petitioner's attorneys, and that's particularly the case if the petitioner's attorneys are going to act for the company at a later date if that's the appropriate thing to do. And they can also, of course, look for attorneys who are willing to give advice for free on the basis that they may be appointed at a later date. But I think the point is it's not straightforward to obtain that advice, and certainly if you're seeking to have discussions with the petitioner or the petitioner's attorney, one has to tread fairly carefully. And that brings us to the second commandment, is thou shalt determine whether you can act or not. Now that may seem very straightforward, and of course that's just part of the process, but there are different laws in different countries, and certainly in the Cayman Islands, if you are nominated by a petitioner, then you as an office holder are required to swear an affidavit declaring that you've done your conflict checks and you are independent and ready to act. Now the issue of conflict, I think everywhere, but certainly in Cayman, is becoming increasingly difficult and increasingly controversial. And it was suggested in a case about a year ago that the very fact that one had been nominated by a petitioner to be an office holder suggested that there may be some sort of conflict, there being a relationship between the petitioner and the IP from the outset. Now, that is a very difficult argument to run, but it's fair to say that it wasn't dismissed by the judge out of hand. And so, when looking at the issue of conflict and the issue of whether one is able to act, certainly from a Cayman point of view, our advice would be that the office holder must be extremely careful in respect of the discussions it's had with the petitioner or with the petitioner's attorney. Because if things turn ugly and there is a fight over the appointment, you may well find that even if there was no conflict before you were nominated, there is certainly an argument made that there is a conflict arising because of the relationship that was developed between the petitioner and the insolvency practitioner. And as a general point on conflicts, certainly where you've had to swear an affidavit saying you are independent, if a conflict issue arises and the court finds that there is in fact a conflict, then of course that can be extremely embarrassing or worse for an IP who has sworn that the contrary position is in fact the case. So moving on then, we've got thou shalt determine who it is that will retain you and why. I think I would probably change that a bit and say that thou shalt establish who is in control. And the reason I say that is that in these large cross-border matters, there are a huge amount of disparate elements, all with interests, all giving advice, and all trying to chop up the position. So in the normal situation, you're going to have the debtor entity, which are going to be demoralised, disgruntled, perhaps not providing information. You're going to have their lawyers who are protecting them. Maybe that somebody's run off with the cash, so you have the criminal authorities involved. You're going to have creditors and shareholders with their lawyers. You're going to have the petitioner with his lawyer. You're going to have IPs coming out of the woodwork with their lawyers, trustees, regulators, you name it. And in that sort of fairly chaotic situation with a cacophony of noise, it's quite important to establish who it is that is in control, and that is to say who it is that is coordinating the process, who it is that knows exactly what is going on, and who it is that has the authority to negotiate the orders, the resolutions, and everything that is needed. Certainly, in experience of one case I did, the issues of control and who had the ability to negotiate were not perhaps as well ironed out as they might have been. And after days and days of working on the case, we got to the Sunday night before the Monday, and it was apparent that one of the IPs in the foreign jurisdiction was not comfortable with the order it's drafting, and he refused to act. And it was very difficult at that stage to find out who it was who had the authority to negotiate with him, who had control of that aspect of the case. And so People have to be got out of bed throughout the night to find out if they were the one who would do it. A great deal of time and energy was wasted. Everything was resolved in the end. But it was a good example of knowing who is in control and who is actually calling the shots. I think in relation to the next one, which is determining what resources you'll need immediately post-appointment. I mean, again, that is something that is relatively straightforward. Safe to say this, that the issue of resources and the resources that are required post-appointment have become an issue in relation to the hearing of a petition, and it certainly has been suggested in a case that the judge should look at whether a particular officeholder has the resources to do the job or not. Now, that, in a sense, can open up a Pandora's box, and I'm not here to say whether that is the right or wrong approach, but there is certainly no doubt that if you come to the hearing having scoped out the job, having a good idea of what is and is not necessary, if you have the resources and are able to point the court to the fact that you have the resources either on island or on standby, then that is certainly going to facilitate the ease of the appointment. And then finally, we say that I shall get itself appointed with a good appointment order. I know that Judy's going to talk about what a good appointment order is, but I would say that if you're clear on control, if you're clear on conflicts, and you're clear on resources, and you have facts behind you, then with a fair wind, the pre-appointment process should go well. Now, there was just one final issue on pre-appointment, so I wanted to make a point about it, and that is, if there was a commandment, or certainly part of the commandment, it said the offshore world is not a false idol. And I make that point because I think those of us who are in the offshore world spend a lot of time thinking that individuals that we're dealing with in the US or elsewhere have real familiarity with the offshore market. And in a number of cases, or in the majority of cases, that is not the position, and people are extremely suspicious of the offshore market and unaware of how it works and how we carry on down the Cayman Islands or elsewhere. Now, to put that in context, since Chapter 15 came about, there have been over 5 million bankruptcies in the US. There have been less than 400 Chapter 15 petitions. So that just gives an example of how few petitions comparatively there actually are. And so I don't think one should be surprised if one finds a US attorney or attorney anywhere else in the world asking whether it is actually the case of Cayman Islands is a stand-up jurisdiction with a fine judiciary and the ability to go to the Supreme Court, excellent lawyers and accountants. I mean, they need to be persuaded of that, and they need to be persuaded of that so that when you get the appointment, you're not in a situation whereby they're trying to circumvent the Cayman Court or the BDI Court or wherever it is for no reason other than they think that it's a fairly shady jurisdiction. So I think it's important to say the offshore court is not a full cycle. I think it's important to try and persuade people, or reasonably to persuade them, that the offshore jurisdiction is one that should be respected and should be brought in fully to the liquidation as it progresses. So that's all as far as I can say. That's all I have to say about pre-appointment.
We're going to give this a try here, so cross your fingers. We are going to move on with David covering the immediate post-appointment commandments. And you'll see that some of the themes from the pre-appointment commandments will work their way into this segment of commandments and the one that follows. So with that, David.
Well, I guess it's the first one, is the obvious one, but it's always the most important. As Simon mentioned, pre-appointment, you don't necessarily have any knowledge or the laws or others. The first thing you're doing is to see what cash, what can you turn into cash is available. And when it's onshore, it's normally pretty obvious. You know which banks to go to, etc. When it's offshore, Cayman, BDI, obviously it's not as always obvious. Case in point is a matter I'm doing in China at the moment. Just to identify the bank accounts, then actually to get yourself on that bank account is like a 2-month-long process. In that time, you have retained lawyers, you've got bills to pay, so you really can't function without it. And it's, I guess it's going to be obvious that most people are going to do it, that's the first thing they do. The other issue you also face is that a lot of the companies you take over, the reason why they're in trouble is by design or just by sheer ineptitude records are generally not, financials are generally not up to date, hiring systems, whatever else. So you have the added struggle of then trying to piece together what the assets actually are. But you need to do that very quickly, which sometimes means getting freezing orders in various jurisdictions to make sure those assets don't disappear, which my experience in China is that they just have complete disregard for the company structure and just move anything anywhere. And it's a real fight to get those assets back later. If you move quick enough, then you can secure those. The other issue I have too is even when you do have books and records, one matter we dealt with the AJW was a fund, was a pipe fund. They put me in, supposedly when we came in, the latest net asset value of the fund was supposedly 600 million. To date, we believe that figure was actually more like 5 million. And they used some quite interesting accounting methods to value their pipe security to the extent that we worked out that had they, basically the pipe fund structure is they lend money, but then they don't pay whatever, they get equity as well. And normally, 60% of companies, they have a lot of shares. And we looked at one instance where they gave this company quite a high price. And if they, the current volumes of the trading would take 1,000 years for them to sell that value, so clearly inaccurate. So that's something we think to be aware of. The other thing is touched on before is you always go after the lowest hanging fruit, so generally that's a cash and bank. And generally, while you can say China when it's more difficult to get access to jurisdictions such as the US, Canada, wherever else, you generally go there first because you know you're going to get generally the cooperation of the courts, the banks, etc. So that is one of the commandments there, is go after the low hanging fruit first. I guess again, obvious to most people. Moving on to the next commandment, which is thou shalt not waste the first chance to obtain information. It's also like to be last. It's an odd thing is that generally up front you do actually get some level of cooperation. Most people aren't familiar with the offshore processes, they're not quite sure. But you tend to find, the more time goes on, that for a combination of this interest, suddenly they're realising the fact that as a liquidator, I could be then suing them, that quickly dries up. So very important to get in there early, get as much information as you can, whether that's from the company itself, from its banks, from some of its lenders, any source you have. And then, because as soon as you have to go through a court process after the fact that quite often you don't have any money, after you found out the cash is king and you've worked out the king is dead, then you get involved in a very expensive process across generally many different jurisdictions trying to get information. And today, most information is now not stored in paper form, it's all electronic form, which actually makes it a lot easier to disappear or move to other jurisdictions that you can't necessarily go and get in. So, I guess it's, as they say, a bit like a crime scene in the first 48 hours is pretty important, similar in liquidation. The third commandment of the post-appointment is thou shalt recognise and use the power of possession of jurisdiction you're in. Again, fairly obvious one, but you'll go to, say, Cayman and British Virgin Islands, Bermuda, to some extent Bahamas, Turks and Caicos, all have a very good legal system that recognise the rights of creditors, investors, and it's well established that the US is a good place to go after information, but the offshore islands, you shouldn't be scared of doing that as well. And we tend to find the courts, if there's especially if there's established some sort of fraud or misfeasance, but they're more than willing to assist, whether me being a local liquidator or US trustees or anyone like that. So I think it's important that you do use it, don't shy away from it when you can. And I know a number of US practitioners in this room, certainly familiar with the Cayman courts, BVI courts, and have had good success with using it. Again, it comes back to that when I say cash is king, because it's, as we all know, it's not a cheap process. Probably at least half the things you want to do are not done because you just simply don't have the cash. You can't raise the cash or anything like that. So, again, it all ties back into cash is king as well. I guess the last one too, I guess these are all obvious, but sometimes senior practitioners overlook it. You've got to look at who your stakeholders are, and you really got to be doing it in their interests. And sometimes it's not always obvious what their interests are. Normally, you take a given and they want their money back, and they want it done as cheaply and quickly as possible. But I've had cases where the motivation is sheerly to basically nail the guy that lost the money with no regard for necessary return. It's an instance where they view it's not going to get much anyway, and they'd rather that money be spent. A lot of it's sort of human nature as well, because they're doing it because they feel as though that they've been duped and they want this guy to pay, or it's someone else's mistake, and they've got to somehow prove that. So part of your job as the IP is always to persuade people that, look, and pretty much 99% of the time, people calm down after 6 months or so, and then what they really do want is some sort of money back from their losses. It's tricky offshore. Quite often you have two diverse groups as well as stakeholders. So you have investors and creditors and often lenders or bondholders, and each of them have different wishes. Some want things just to be done, especially like the fine, the hedge fund, private equity guys just want to really get in and out very short term, which is not always in the best interests. If you're trying to sell an asset that you know is going to take quite a while to sell, and you'll get some of the longer term private investors who are quite happy to sit there and wait, so you have that natural tension there. But how you deal with it is, as per the command, understand all their motivations, and you can try and come up with some innovative ways to deal with all. And one instance I had there was we had shares in a Canadian oil sands company, and it's not our job as liquidators to sit there and determine whether it's going to be of any value. It's our job generally to get there, sell it. A few voracious investors claimed that this thing was going to be worth a lot more money down the track, so we came up with a structure where they sold some, we gave shares in species to others. Interesting footnote to that is 2 weeks ago that oil sand producer just went into the Canadian the creditors CCAA process. So I hope those who took those in species got out before they're hitting up. They're the commanders from media posting.
David, just a couple of things, just looking there. I sort of got rather too into the commandments this morning, and I came up with another couple which I'm thrilled to hear. I mean, I think the first one, following on from the cash king point, is that you know, one shouldn't rest on the Sabbath day until you know exactly where the assets are, exactly what the setup is, and exactly what it is that you are dealing with. And I think it's particularly important when it comes to issues such as service providers and funds, which we very often deal with. It's important, obviously, to find out where the assets are, understand the structure and what have you, but it's also very important to understand the terms upon which your potential targets have been engaged, and so it's important to make sure that you cover everything, to make sure that in the engagement letter there are analysis surprises, for example, in relation to limitation, for example, in relation to the retention documents. I also think, following on from David's point in relation to recognise and use the power of possession and jurisdiction, I mean, there's a sort of ancillary point to that, which is that one should honour their own statutory powers, but they shouldn't cover another's statutory powers. And that's just very quickly to make the point that there has been an agonising offshore sort of common law world about what level of common law assistance the foreign court can provide to the domestic court. when a company has gone into liquidation. It's been very unclear exactly what the terms of that assistance could be. Recently, there's a case which I'm sure many of you are familiar with called PwC and Singularis, where PwC, where the auditors, the media auditors of the Cayman company, the Cayman liquidators wanted to get their hands on the Cayman Islands, on the auditors' working papers, but the Cayman Islands legislation would not allow for the Cayman court to order that information to be turned over. So the Cayman liquidators went to Bermuda. They tried to use common law assistance in Bermuda, use the Bermuda Companies Act, Section 195, and have the audit working papers turned over. And that succeeded at first instance, and it failed ultimately in the Privy Council. And the reason it failed because the Privy Council, having agonised 5 separate judgments, it was a ridiculous amount of jurisprudence that went into this, but they eventually came to the conclusion that the position is that at common law, a foreign court may assist, but it may not provide assistance which is more than that you could have obtained in your home jurisdiction. So in this case, the foreign court of Bermuda could assist in terms of getting the auditors to turn over documents, but it couldn't go as far as to ask them to turn over their working papers, because that was not the power that was available to the Cayman liquidator in Cayman. And that's why I say you should honour your statutory powers, but you shouldn't covet other people's powers, because as a matter of common law, you won't be allowed to use them. And the final point I wanted to make in relation to David's excellent point about understanding the motivations of your stakeholders. I mean, I think you can honour your stakeholders up to a point, but there comes a stage where you've got to, or where you may have to part company with them, simply to make the point that there will come statutory positions where you have to diverge in the interests of your creditors. For example, if you reject the proof of debt, you're going to become adverse to that stakeholder and there's going to be adverse proceedings against them. But there's also the point that even if a creditor committee or a liquidation committee is trying to tell you what to do as a Cayman liquidator, you've got to be jolly careful about how you proceed, because ultimately they only advise and you are liable for the decisions that you make. So it is very important to understand how stakeholders feel about things, how they want the liquidation to go. It makes life a great deal easier. We always also have to remember that there will come a time when you're going to part company, and it's just important to know that and always have the forefront of this.
Thank you, Simon. We've heard some good advice, some good commandments for the pre-appointment and immediate post-appointment periods here. And we're going to turn to Julie next. We have run through our allotted 10 commandments, so we have a slide here that says more, and we say yes. And so Julie will give us some of these and try to give us some perspective for the period that will occupy the IPs for the most part, the period through the conclusion of the assignment.
Thank you, Arnie. Okay, so now that the appointment has been rendered, I'll give you my perspective as a Canadian attorney of what you can do if there are assets that are identified in Canada and more particularly in the province of Quebec, and what you should do if you want to come up to our jurisdiction and obtain recognition. So before we even go into making the court happy and the regulatory body happy, I think one of the things that you have to be mindful of is you should get yourself someone locally who will assist you. So if you're an insolvency practitioner and you've been appointed by an offshore jurisdiction, you should not do anything in our jurisdiction before you have some sort of appointment and you're assisted by someone who is a local insolvency practitioner. And so if you have a firm with an office in our jurisdiction, that would work. If you don't, you should retain someone locally and obtain an order recognizing your appointment and being assisted by the local insolvency practitioner. Otherwise, you just can't go in there and do what you have to do without that. You should make sure before you do anything as it regards to any assets or records or documents that are found in our jurisdiction to be in contact with the regulatory authorities. In our province, it's called the AMF, but the Financial Regulatory Authority, and you should not come into the jurisdiction and take any records out of the jurisdiction or even copy anything before making sure you have been recognized and you have an order in our jurisdiction. Otherwise, you'll start your relationship with our courts really the wrong way, and the first day you'll come in the courtroom and ask for some kind of recognition, you'll have a strike against you. So you have to make sure that I think the first thing, of course, is to get local legal counsel. That will help you identify what you need to know and will enable you to be guided through, all the bodies, the regulatory bodies that need to be contacted. And of course, you'll benefit from the solicitor client privilege, which is an advantage. So those are really very basic things you need to know. You should also know if you want to come up and recognize or reform your judgment from your jurisdiction. You have to be ready to defend the fact that the order was rendered in the jurisdiction because it was the center of main interest of the debtor of the company that has been liquidated. You have to be ready to make that demonstration. So, we've seen cases in Quebec where people have come up and wanted to have judgments recognized, and they weren't ready to make the evidence and show why the comey was where it was according to them, and that's quite important. You have to justify it. You just can't take for granted that the court will presume that because there's an offshore judgment that's been rendered that the comey will be where the order was rendered. So those are pretty important commandments as well. You have to make sure your judgment is non-appealable. And if it's not, if there's still an appeal process that's possible, you have to be able to explain why you want to get recognized in Canada before the appeal period expires. It's possible, but that has to be justified as well. So those are pretty standard and important things to remember. What should be in your appointment order? I mean, I was talking to Simon who was telling me we can't be too creative about it because it's very standard. It's in the Act, and it's according to 2 sections of their Act. That's fine, he says, because that gives them broad powers and they have a lot of wiggle room with that. But if you need to take measures very quickly and you need interim orders, you have to make sure that you get that in your appointment order so you can have it recognized if it's possible, and then you can enter into the jurisdiction and start doing what you have to do. Thou shalt keep input from creditors whenever possible and respond to queries and claims as efficiently as possible. Of course, I mean that seems pretty important. In Canada, the practice that has been developed, and I'm sure that it has been also elsewhere in our domestic insolvency files, is that the insolvency practitioner will set up on his website a page where all the proceedings are posted. And the courts give a lot of value to that, and they actually, in our domestic files, order the insolvency practitioners to do that when there are big cases so that creditors can follow and keep up and know what's going on. And so that's something I think I've seen in big files which have international ramifications, but that's very appreciated by the courts in Canada when that's possible. Of course, you have to have the means for that and with someone to keep that, up to speed. But I think it's very, very useful. In terms of selling assets, of course, before you sell any assets in Canada, it is recommended that you obtain valuations like anywhere else in the world, I would think. And, if we think that there's going to be a contestation, we would get more than one valuation in order to make sure that we have the right figure. And then there can be a sale process that is authorized. If it's authorized in an offshore jurisdiction, we just have that recognized and we execute it. We can also have it organized in Canada only if we need to, if the assets are in Canada. And then we can have the assets marketed. And once we're ready to sell, we would normally go back to have the sale approved and get court blessing. it's interesting also that we can get a vesting order when we sell assets, so we can have assets sold without any guarantees, so we can just clear all the guarantees that encumber the assets. So that can be provided, and we've developed quite a big case law body on that.
Is that even a guarantee under the law of the foreign country?
Well, that's a good question. I don't know how that would be recognized in another country, but definitely in our jurisdiction, we have that recognized. Maybe then if you need to go and have that recognized somewhere else through your recognition laws, maybe that would be possible. But what I've done is really more Canadian type vesting orders, and they're quite efficient. You have to make sure when you sell assets in a liquidation file or in an insolvency file, you want to sell them, of course, free and clear, as is where it is. The purchaser will ask you for a vesting order and will ask you to buy them without any encumbrances, but you can't make representations. And we've seen a case recently, quite an interesting case, where a trustee has sold assets and the buyer wanted to buy the assets free and clear. And although it was a as-is whereas sale without any representations, because of the request that there be a vesting order and that the sale be free and clear, after the sale there were some claims made on the assets, and the trustee was sued. Because based on the fact that the purchaser asked for a vesting order and for assets free and clear. The case finally was settled, but it gave rise to some talk in our world as to, how tight the wording of your documents have to be when you're selling assets as an insolvency practitioner to make sure that you have no liability. It's the duty of the purchaser is to make sure that he gets a vesting order, but there's no guarantee at the end. If there's a tax authority that will try to put its hands on those assets, you have to be very mindful of that. So one other commandment that we wanted to talk to you about is thou shalt litigate only where necessary and compromise where possible. Now, that's not always easy at the beginning when we begin a file and we have a recognition order to determine whether or not the litigation is worth our while, but definitely when we identify a potential litigation and we see that the litigation is going to become a big war, then I think we have to be mindful of the fact that we're spending the creditors' money and be proportionate about the way we go by it. Now in Canada, there's been a lot of talk, and the judicial authority is looking very hard at what the lawyers and the insolvency practitioners are doing in insolvency and litigation and liquidation files. They are very mindful of how many lawyers come to court on a file. What they're doing is proportionate, and they're integrating that into rules of practice. Because an insolvency file, whose money are we really spending here? The creditors are not watching on a day-to-day basis what we're doing and the efforts that we're putting into what we're doing, but the courts are reminding us and making a lot of comments when they see that firms come to the court with 3 lawyers on file and trustees are 2-3 people coming to court, and they want to, I think, make sure that the efforts on the litigation are proportionate, and we are very mindful of that. And so when you are an insolvency practitioner or even a lawyer in another jurisdiction and you're sending a team to court, I think you have to be mindful of that, because you may not always know what's going on, but the courts in Canada are looking at that and telling the practitioners, this is the creditor's money and you should not be wasting it, so think of that before you come to court. And so when a compromise becomes obviously necessary, then that's what we should recommend. We should try to settle the litigation when we realize that we're going to spend more money than it's worth, and we are very mindful of that. Thou shalt keep to minimize competition and litigation as between office holders and as between yourself and criminal authorities. Again, this is not always obvious at the beginning of a file who is going to be a competing office holder. I can tell you that in some files, we were shocked to realize who was becoming a competing office holder. And so, once you realize that there is a competing office holder, I think if that person is not going away, the only thing you can do is try to work with that person and maybe come up with a protocol or an understanding. I know in the Stanford International Bank file, after so many efforts, the team was able to come to an agreement with the U.S. receiver, and that was quite an accomplishment, I would say. And it took a lot of efforts, but it was the best thing to do. And I think it was for the benefit of the estate and the creditor. So if it was possible in that file, I think it's possible in any file that you will ever work on. And I know I was laughing because his office was involved in that, and I was really impressed to see how they were able to do that. And finally, thou shalt end the appointment in a way that maximizes the distribution and minimizes liability. Of course, I think that's the end result that we're all looking for. And I think that all the steps that are going to be taken are important to maximize distribution and minimize liability. In terms of liability, I think I was talking to Arnie about this. We have limited liability for insolvency practitioners, and the orders that are rendered limit the liability of an insolvency practitioner, so there's no major risk. There are provisions in the orders which limit the liability, and but of course for the estate, well, you have to manage that and make sure that you minimize that as much as possible. So I think those were my comments.
Great, thank you, Julie. Look here to see how much time we have. Not very much, but if we have a few questions, or I know that we have very experienced persons in the audience. If you think that there's a commandment out there for cross-border insolvencies that we've missed, we'd love to hear it, or any comments that you might have from the floor. Otherwise, any questions, comments? Otherwise, I would ask you to please join me in thanking our panelists today, and thank you for bearing with us with the adventurous PowerPoint for this presentation. And I would urge you to stick around. I know we have other good panels coming this afternoon, and the drinks shortly after that. So thank you again.